तो आज के लिए जो मुझे मौजू दिया गया है वो है म्यूटेशन. It is an important topic, especially for the lawyers who practice on the civil side. And it is equally important for all those who practice on the criminal side. They are criminal practitioners and not the criminal lawyers. So this mutation relates to the land, and the land is basis of all the disputes. So in order to understand the mutation, we are to start with the Constitution of Pakistan. Article 23 of the Constitution of Islamic Republic of Pakistan says, every citizen shall have the right to acquire, hold, and dispose of property in any part in Pakistan, subject to the Constitution and any reasonable restrictions imposed by law in the public interest. So the careful reading of this article shows that the word every citizen is used in it. Every citizen implies an individual, so when we give him the power to dispose of the property, this article is giving the ownership to an individual person. So this article guarantees the rights of an individual as the owner of any property. He may acquire the right in the property and he may dispose of the property. So this section, this article, is the basis of the acquisition of rights and of the disposal of the rights. We derive right from this article of the Constitution. Article 24 says, no person shall be compulsorily deprived of his property save in accordance with law. Again, the person is used, meaning thereby that every individual has the right to retain his property. So Article 24 protects the rights of an individual regarding his ownership. So these two articles are the basis of the ownership of an individual, acquisition of the rights of an individual, and disposal of the property by an individual. Now every individual may dispose of. Under Article 23, the word dispose of is used, meaning thereby that he has the right to transfer the property. So transfer means passing of the property from one hand to the other. Disposal means transfer of the property. And the transfer means passing of the property from one hand to the other. Transfer of property, how it is effected. There are two ways of the transfer of property. One is the transfer of property by act of the parties. Number two is by operation of law. So these are the two modes of the transfer of property. By act of party means the parties have the right to enter into a contract to pass on the property from one individual to the other. So the ownership is transferred by the act of the parties. And the second is the transfer by operation of law. So how act of parties is allowed to transfer the property? For this purpose, we have a statute, and that is Transfer of Property Act. Transfer of Property Act gives the powers to the individuals to dispose of their property in those methods and in those ways which have been described in the Transfer of Property Act. Number one is transfer through sale. That is Section 54 of the Transfer of Property Act. Sale is transfer of ownership for a price paid and partly promised to be paid. But Section 54 says that the sale shall be effected through a registered instrument. So here we divide the transfer into two parts. One is the transfer through a registered instrument, and other is a transfer through oral transaction. So this provision divides the ways of transfers, methods of transfers, mode of transfer into two parts. One is a transfer through a registered instrument, and other is a transfer by oral agreement, by oral transactions. Similarly, Section 58 relates to the mortgage. Although in mortgage the ownership is not transferred, but certain interest is transferred. So the transfer of interest by an individual is also effected through a registered instrument. And then there is another provision of exchange under Section 118. One party gives his property to the other and gets the other property from that. So this transaction is called exchange. It is also effected through a registered instrument. And then is the gift. There are two provisions of the gift. One relates to the Muhammadan law and other relates to the transfer of property act. The mode of transfer under Muhammadan law is different from the mode adopted in the transfer of property act. When we follow the transfer of property act, the gift requires registration. But when we are invoking the provisions of Islamic law, then its ingredients are to be fulfilled and the title of the donor passes on to the donor. We are not discussing the gift, but it is a matter to be told that it is a transaction. That the title of the donor passes on to the donor on the completion of gift. It is a Muhammadan law. Then there is a waqf. Waqf under Muhammadan law, waqf through a waqf validating act in 1912. So these are the modes whereby the title of the transferor passes on to the transferor. But we have seen that all these modes prescribed in the Transfer of Property Act relate to the registered instruments. Under the Transfer of Property Act, all transactions are compulsorily registerable if they exceed value of 100 rupees. Now there is a transaction through operation of law, that is inheritance. When one person dies, the succession opens up and the title of the deceased passes on to his legal heirs automatically. So these are the methods prescribed by the Transfer of Property Act, which requires compulsory registration. And the registration is a title deed. But Transfer of Property Act itself states that these sections are applicable only within the municipal limits. The property situated within the municipal limit shall be governed by the Transfer of Property Act. And the property which is out of the limit, for that transfer there are two modes. One is transfer through registration of the document, and the other is oral transaction. Now, for the purpose of oral, we are to see the definition under which they are going to transfer the property. Suppose a person is selling his property through oral transaction. Then what happens? He enters into an agreement, receives the amount, and delivers the possession. Then in this situation, price is a sine qua non for the purpose of determining the sale. So the oral sale is complete. So in this situation, transaction is completed by the parties without any writing. So if it happens like this, then after some time, disputes may arise whether the property was transferred or not. Then what should happen? So for the purpose, the state is responsible to protect these transactions. The oral transactions are entered into by the parties themselves. The state has nothing to do with it. Sale is entered into by the parties, exchange is entered into by the parties, gift is entered into by the parties, by the oral transactions. So the transaction is completed by the parties themselves, not by the state. But where the registered deed is required, then the transfer of property comes into play. But when there is an oral transaction, then there is no need of any writing. But the state is responsible to create evidence for the purpose of determining this transaction. Now the transactions we have studied are of two types. One through registration deed, registered deed, and other is oral transaction. Now we are discussing oral transaction because there is a registered instrument that is itself a deed, that is a transfer deed, that is a title deed, that is the ownership of a party. But where there is oral transaction, where the act of transfer of property does not apply, then we are to enter into an oral transaction. So oral transaction is a thing which requires some record. So for this purpose, the state had to make the arrangements for the purpose so that there should be some evidence to know that the parties had entered into a transaction. So to make the arrangements, there are three instruments and the acts created by the state. Number one is Land Administration Manual. Number two is Land Record Manual. And number three is the Land Revenue Act. I'm going to read Land Administration Manual. Paragraph 372, Chapter 10 of the Land Administration Manual and paragraph 279 to 280 of the Settlement Manual refer to the record of mutations. So this record shows how a mutation is prepared. It gives the detail thereof. So if you want to go through it, you will find that it gives the methodology of entering into a mutation or regarding the oral transactions. To make arrangements for the oral transaction was the duty of the state, so that to avoid the disputes, there should be some evidence. So the mutation register is part of the revenue record. And the Land Revenue Act also provides Section 42 for the preparation of mutation. Under Section 42, it has been provided that when any person acquires any title through sale, exchange, mortgage, and there is another provision that lease for more than 1 year, then the person acquiring the title, it only relates to the oral transactions, will report the matter to Patwari. Then the Patwari shall, after hearing his statement, record it's in Rapat Roznamcha. The Rapat Roznamcha is the statement given by a party who is acquiring the title or who is delivering the title before the Patwari. So here we see that up to this time there is no mutation. So the title completed before entering into the mutation. So the mutation is not a title deed because the transaction already completed between the parties by the act of the parties. When by the act of the parties the transaction is completed, then evidence is to be created for the purpose of determining whether there was any transaction or not. So the mutation itself is not a title deed, but it is simply indicative of the fact that there was a transaction between the parties. So if there was no transaction, then the mutation is a nullity. But if there was a transaction, then the mutation is the responsibility of Patwari. It is when a report is given to Patwari, now it is responsibility of Patwari to record it in the mutation of register. Then he will enter it into a register that this transaction took place prior to the entry of the mutation. So the mutation is indicative of an pre-existing right. It is not itself creating any right, but it is indicating the pre-existing right which has been created by the party through the act of the party or by operation of law. So then the mutation is entered under section 42. Then it is sanctioned by the revenue officer. Now it becomes a complete piece of evidence to indicate that the parties had entered into a transaction. So there are several authorities that when there is mutation in dispute, the party alleging should prove the transaction, not only the mutation, because the title of the transferor passes on to the transferee, not on the mutation, but on the basis of the transaction which took place prior to entering into the mutation register. Now there are certain authorities which are necessary to be told to the beginning line. 1990 CLC, page 321. Mutation signifies alteration of names and entering in the revenue record to bring the record up to date. Revenue record is meant for the fiscal purposes. So from whom the revenue is to be collected? This will be stated by the record itself. So the record should be up to date. And for the purpose of making it up to date, there should be a mutation entered into when there is a transaction. Because after transaction, the original owner loses all his rights from the property and divests himself from all the rights. So the new rights are created in the new person. And that new person shall be recorded in the record for the purpose so that they may recover the revenue from him. In this authority, decision on a mutation is not a final adjudication. On question of title. It is not a final adjudication on question of title because question of title relates to the transaction which earlier took place. It does not relate to the mutation. Mutation comes into existence after the transaction was completed by the parties and the title of the transfer passed on to the transferee. So the title of the transferor passed on to the transferee prior to the existence of mutation. So mutation is simply a document which is evident of the transaction which earlier took place. Another authority, 1999, MLD, page 138, mutation was sanctioned through summary proceedings intended to keep the record update for collection of the revenue. 2017 YLR, page 1249. Mutation would not convey any title if someone claimed transfer of title by mutation. It was necessary that transaction should be proved, being evidence of the transaction. So it is 1999 MLD, page 138. Now another authority, PLD 208, Lahore 808 2017 YLR, page 1249. It is an important authority. It says presumption of truth was not attached to the contents of mutation. No presumption is attached. When the transaction is disputed, no presumption shall be attached to this record, but the parties shall be bound to prove the transaction. So the crux of this authority is that the parties are to prove that the transferor passed on his right to the transferee through a transaction which took place prior to the mutation. Then the mutation is a corroborative piece of evidence. Once he is proving the transaction, then he may get the support from the mutation that this transaction took place in this way, and we got it incorporated in the mutation register. So the mutation is a corroborative evidence of the transaction. Another authority, PLD 2020 Supreme Court, page 38. Mere attestation of mutation by itself does not furnish proof of sale. And when any such transaction was questioned, the person who wanted to derive the benefit from that transaction had to prove the transaction. So it is the duty of the person who is deriving benefit from the transaction has to prove the transaction. If he proves the transaction, the mutation is proved. But if he fails to prove the transaction, then the mutation carries no weight. Another authority, PLD 1977, Quetta, page 60, entry in mutation register does not form part of record of rights, meaning thereby that the mutation is not record of rights. When it is incorporated in Jamabandi, then the Jamabandi becomes the record of rights. Then some presumption may be attached to Jamabandi, but no presumption to the mutation. Hence, no presumption of truth is attached to such entries. Section 52, Land Reforms Act, hence held not applicable, so as to raise presumption of truth in respect of entries in mutation register. At the best of evidential value, neither creating nor extinguishing title. There is another authority, 2004 SCMR, page 1723, 1986 PLD, page 198. Somewhere on the other hand, supported by other evidence, person in whose favor such entries were made could rely upon them. Here is a distinction between the basis of a document and the reliance of a document. So this mutation cannot be the basis of a transaction, but it may be relied upon for the purpose of proving the transaction. So here is a slight distinction between relying on a document and basing on a document. So your title cannot be based upon mutation. The title shall be based upon the transaction which was entered into between the parties, or which was acquired by the operation of law. So far as this document is concerned, it is a document which may be relied upon. So the documents which are relied upon have the value to strengthen the contention of a person. So this document is meant to strengthen the contention of the person who is deriving benefit from the document. But it itself is not a basis of his transaction. So in this authority by the Supreme Court, it was held that this is a document which can be relied upon. (207) SCMR, page 729. It is one of the most important authorities. Mutation had to be proved through evidence of title. Person deriving title under mutation had to prove that transfer did part with ownership of property in favor of transferee, and that mutation was duly entered and attested. So it was duly entered and attested after the transaction was completed. Before completion of transaction, there can be no mutation. So all those documents, all those transactions which do not create right in favor of a person cannot be incorporated in the mutation. Supposing that A enters into an agreement with B, agreement to sell. He pays the amount, but it is simply an agreement. It is not creating right. So as it is not creating right, so it cannot be entered into mutation. So the mutation is entered into only when the right is created in favor of one person and the other is divested from all his right from the property. (1993) MLD, page 1078. 2000 YLR, page 974. 2012 CLC, page 1651. 2005 CLC 1571. Mutation is not a document of title. So in the stricto sensu, mutation is not a title deed. Now, here a question arises, which is usually not known to the generalizers. So it is necessary to explain the same. There are two acts, Land Settlement Act and West Pakistan Compensation and Rehabilitation Act. West Pakistan Compensation Rehabilitation Act 1958, Land Settlement Act 1958. These two acts were promulgated for the purpose of determining, allotting, transferring the rights to the EAQ owners. There are certain properties which were declared evacuee by the state, and the displaced persons were declared entitled to their allotment. So some properties which fall within the definition of land were governed by the Land Settlement Act, and the properties which were other than the land were governed by the West Pakistan Compensation and Rehabilitation Act 1958. So these two acts relate to the two different properties. When the property is acquired, allotted, transferred to an evacuee person, the RL2 is issued. RL2 is a document whereupon the allotment is ordered and then confirmed in favor of the person who was evacuee claimant. So that RL2 is a title deed. Similarly, the property, which is not a landed property, which is other than land, maybe house, maybe plot, maybe shop, for that evacuee property, the Deputy Settlement Commissioner was authorized to transfer the same. And for that purpose, two steps were taken. Number one, the provisional transfer order was issued, then the permanent transfer deed was issued. The relevancy of this point is that when there is a PTD, there can be no mutation. Mutation relates to the land, not to the property other than the land. So where there is a PTD of the property, we are not expected that there should be mutation. A PTD itself is a title deed conferring the right on an evacuee claimant by the state. So PTD does not require mutation. Similarly, RL2 is a title deed. There is no need of any mutation to incorporate it in the revenue record. RL2 is incorporated in Jamabandi without any mutation. Sometimes some people ask, you have got RL2, where is the mutation? They don't know that RL2 does not require mutation. Straight away from the RL2, the title shall be incorporated in the Jamabandi. So this was the question which was to be cleared before the younger generation, that the PTD does not require mutation. RL2 does not require mutation. RL2 itself is a title deed entitling a person to be incorporated in Jamabandi. PTD in itself is a title deed, does not require any incorporation in any record, because there is no revenue record of the urban property. So the land relates to the Settlement Act, and all properties which were evacuated related to the West Pakistan Compensation and Rehabilitation Act and were governed by the Settlement Department. So mutation, in the nutshell, mutation is indicative of pre-existing right of a person. It is not creator of rights. Thank you very much.